your win. So that, see, it's supposed to be Naima mwenzako, then Naima consults for the firm. Remember what we had told you to put? Remember those words we had told you to put? No. No, but see the way she has put consults is big and bold. It's not supposed to be that. Remember what I was explaining?
So that now I can now, as a high court, as a superior court, I can then now. So karibisha huko chini. Bila isikeze karibisha huko chini. Bwana watu ni good frustrate.
Salim Swaleh Abdallah, John Musundi wa Bomba, John James William Mokoha.
For the third respondent, my name is, will be three of us. My name is Dan Sanomari. No, for the third is Mr. Nyaberi. So, this is Mr. Samson Nyaberi. For the fourth respondent, my name is Dan Sanomari, Mr. Sam Nyaberi, Mr. Shatra Kwambui.
Good afternoon. I'm present, thank you.
Good afternoon, Your Honor. Yes, Your Honor. Ario, Your Honor. I appear alongside my senior, Mr. Oloch, present.
If you please, Your Honor. Good afternoon. Mokuna, I'm present for the sixth respondent.
Perhaps as a housekeeping issue, they will be allowed perhaps to take their seats at the side. They can be able to follow the proceedings.
So some can sit there now.
Thank you. The application is supported by the grounds on the face of that application and the supporting affidavit. Deponed by one Inspector Nicholas Njoroge. In a nutshell, the IO in the face of that application indicates that he is investigating several offenses, namely conspiracy to commit a felony, contrary to Section 393 of the Penal Code, as read with Section 389 of the Penal Code. The other offense, Your Honor, is personating a person employed in the public service, contrary to Section 105B of the Penal Code. And the other offense, Your Honor, is abuse of office contrary to Section 101, subsection 1, as read with Section 102A of the Penal Code, Your Honor. All the respondents were arrested on the 23rd June 2024.
Your Honor, before counsel proceeds further, it is not the prosecution that has informed that, then we'll be able to proceed. Proceed, Your Honor.
I'm not taking to take the dog
That is what we are asking.
for the reason that you have not believed when I was in my court, it was served upon the respondents.
You know, if I,
Sorry, I think what the Somali is saying, that the serve alone is good enough. That whoever we can put on the dog and the opponent, we serve them some cross-examination. But I think even the fact that we also received this application just like 45, the opponent in this particular judge, we serve them some cross-examination.
it is upon the investigator to take an oath and defend his affidavit. And that's the basis we are saying. The investigator takes the doc, he lays why he thinks what he has deponed are compelling reasons. The suspects cross-examining for the court to get the truth and the veracity of this matter. The prosecution can lay the law and can rely on the information that has been produced by the investigator to convince the court. You know, there is no way the prosecutor can take the role of an investigator. Article 157 completely divorces the prosecution from the role of investigation and grants that power in Article 244 and 245 of the Constitution to the National Police Service Commission. And this were 14 days. They cannot hide behind the good office of the prosecutor. So we are saying, let him explain to us. Because some of the averments here, the prosecutor has simply received this like us. May the court agree with us that that is the position of the law. And on the question that we must serve a notice to cross-examine, you know, that is simply to tell us that the prosecution wants these suspects, these respondents, to be kept for long. Because then we'll be saying, give us time, let us respond, make a replying affidavit. They also do a further affidavit, then we file a notice to cross-examine. It is general practice rules that once an affidavit has been sworn by the DCI, he takes the dog, he convinces the court and convinces the counsels here. If he's convincing enough, we might not even oppose for 14 days.
Can I have a bite of the chair? This evidence is going down on record. And the substratum of what is going into the record is by way of an affidavit. Matters are conducted before court of law. How evidence is harvested. They call their witness into the dock. They examine that witness. We cross-examine. If there is any dent that we have done onto the evidence, they re-examine. By this affidavit, Your Honor, after having laid basis why they want 14 days, allow us to cross-examine that deponent so that we can crystallize the issues and dispel whatever underlying issues that there are about the compelling reasons that they imagine to have in this affidavit. Thank you.
Being sworn in court on the dock. We already have an affidavit on record. The IO does not need to go to the... Your Honor, the reason why we needed a notice to cross-examine the deponent is one, so that we can know in which particular paragraphs that the witness is being deponed. cooperation. He is not dressed for court. The court can have a look at the witness. That is why we needed a notice to cross-examine.
There is a content.
It is not the content. You look at the police standing orders, they require a police officer to attend court and be sworn in a particular dress code, Your Honor. And that is why we needed a notice to cross-examine a deponent. Further, Your Honor, you'll note that Section 145 of the Evidence Act strictly talks about witnesses. The officer we have in court is not a witness in any particular case. He has only deponed an affidavit. And we'll be asking the court to be guided by that affidavit in granting us the 14 days that the state has requested.
This honorable court, touching the matter in question, shall be the truth, nothing but the truth, so help me God. Inspector Nicholas Joroge, working at DCI headquarters, Operation Support Unit. The Honor have shown this affidavit, giving reasons as deponent in the supporting affidavit, seeking to have the first and sixth respondent remanded at Capitol Hill Police Station for 14 days so that I can finish my investigations. Your Honor, as the counsel said that they want to cross-examine me, we can go through the supporting affidavit, paragraph 1, paragraph 9, and if they have any questions, they can ask.
Before you let me inform this court the reasons as to why you needed a 14 days.
Your Honor, as earlier stated, some of the reasons that have made me to come to this court and seek for more days can be found in paragraph number 9 of my affidavit. That is, I need time to record statement from main contractors who are based in UAE and who are victims in this case. I also want to obtain company registration details from relevant offices in Kenya, Dubai, and South Africa. That, Your Honor, some of the respondents are employee at the Prime Cabinet Secretary Office and they are hired to interfere with the ongoing investigation, if released at this moment. And that the nature of the investigation I'm carrying is complex. It also involves foreign communication channels, and must observe the diplomatic protocols, thus getting information needed from various embassies will take time, Your Honor. So, Your Honor, I'm seeking to have the 14 days granted by this court as prayed. And after investigations, the case be mentioned, and also I will update court. Yes, Your Honor.
Lead investigating officer who has been given this file to investigate. And do also confirm that the area of investigation is only on 3 items. That is, attempt to obtain money by false pretenses, personating a person employed in the public service, and abuse of office. Those are the 3 thematic areas that you're investigating about. And confirm, therefore, that the 1st, the 3rd, 4th, and 5th respondents are persons employed in the cabinet, Prime Cabinet Secretary's office. The 1st, 3rd, 4th, and 5th. What is otherwise the position? What is otherwise the position? Only the 4th respondent. That is Salim Swaleh Abdallah. Thank you. Now, of these others, that is the 1st, the 3rd, and 5th, confirm that you have not had occasion to or information that they have offices at the Prime Cabinet Secretary's office. And your application has not is bare of any annexure. It is just your affidavit and the application that you have presented to court. Now, I'm interested to know, or before I even get there, that all these you are swinging into action was orchestrated by intelligence, the intelligence that your office received. Thank you. Now, of that intelligence, and I want now to go to paragraph number 9 of your affidavit. Let me start with number C, 9C, ongoing investigations. Is there any other case that your office is handling where there have been previous investigations that are ongoing against the 1st, 3rd, 4th, and 5th respondents?
No.
So therefore, this particular averment